Welcome back, everyone. Now, let's move on to session 2, where we will be covering the industry perspective panel discussion on PCT. Before starting with the session, I would like an opportunity to introduce our panelists. Bishram Singh Chouhan is heading Global Branded Portfolio IP at Sun Pharma, has 17 years of experience in IPR and is a qualified Indian patent agent. With a doctorate in pharmacy from MSU Baroda, he began as a medicinal chemist before transitioning to IP. He has worked with major Indian pharma companies like Zydus and Dr. Reddy's at Sun Pharma for a decade. He manages global IP for branded products, LCM strategies, and due diligence for licensing and asset transactions. Mr. Manish Garg, Assistant General Manager, Legal and IPR, Rajdhani Petrochemical Private Limited. He is an IP management expert with 24 years of experience in patent, trademark designs, and copyrights. As Assistant General Manager, Legal and IPR at GSP Corporate Science Limited, he specializes in IP strategy, patent prosecution, FTO analysis, and legal matters. He has a master's in business laws and a master's in trade law and WTO, NLU Jodhpur. A visiting faculty at Gujarat-based institutes, he has judged moot courts and conducted IP training. His expertise spans international trade law, WTO policies, and patent law compliance. Mr. Kaushal Joshi, Assistant Vice President, IP Head, Kashiv Biosciences. Kaushal Joshi is the Associate Vice President, IP and Legal at Kashiv Biosciences with 19 years of expertise in pharma, biopharma, patent and corporate legal matters. He specializes in IP strategy, biosimilar litigation, patent prosecution and due diligence. With hands-on experience in protein purification and vaccine development, he has filed over 150 patents since 2019 and drafted 100 plus applications. He has worked as Cadila, Gelmark and Lupin Pharma, a registered patent and trademark agent. He holds a master's degree in biotechnology, an LLB and a LLM. Manisha Tiwari is an IP expert with 19 plus years of experience in intellectual property management, specializing in pharma, patents and litigation. She holds an M Pharma from Naipur Mohali, an LLB, and has been a registered patent agent since 2008. She has worked at K&S Partners, handling diverse IPR cases, and is currently focused on litigation strategies and global IP tracking. She has also completed certifications in strategic management, IIM, and US Patent Law and Practice, George Washington University. Gopi Trivedi is the senior partner and head of the patent division at YJ Trivedi and Co. With nearly 2 decades of experience in intellectual property, holding degrees in computer engineering and law, she is a registered patent agent and certified patent valuation analyst. She specializes in the managing national and international patent projects across engineering, software, chemical, and pharmaceuticals. She also leads the firm's IP valuation and management team. A frequent speaker and panelist at global IPR events. She actively contributes to organizations like AMA, INTA, and GCCI. Under her leadership, YJ Trivedi and Co. set a world record in 2018 for the highest number of patent filings. Now we can resume with the session. So,
welcome, Vibrant Gujarat, and delegates, welcome to Vibrant Gujarat for this panel discussion. I am Dr. Ahilan, Joint Controller of Patents and Designs. I am moderating this panel discussion. We have expert person in this panel. So this today's program, this patent and trademark, it's a combo. So when you have a product, obviously we need some brand name. So it is, when we are talking about the global protection on the patent, it is important to know about the international protection on the trademark and brand side also. So my humble request, participants, please enjoy the whole day program to reap the benefits to the fullest extent. The Vibrant, this global summit is being conducted in here in the state every year, global summit. So we are, few years back we were talking about the term glocal, means think globally, act locally. Now it's time to give it back to the rest of the world. So I am introducing two terms, either it can be a loc glow or loc ball, meaning that protect your local invention in international level, global, multiple countries. So one side we are talking about that number of filings in the patent office, the domestic innovators from India, that it's gone up to nearly 60%. When we are reaching the 1 lakh total figure, nearly 60% contribution from the residents. But at the same time, if we compare the number of PCT international filing, it is less than the 10% of the contribution. So in this system and this panel, we are going to discuss about we have different panel experts here. What are their experiences in using the PCT international system and their experience while entering into the national phase, and what are the challenges they are facing, what are the suggestions that we are taking up, and finally what we have to contribute to increase the number of applications also. We have experts from the different field. Let me start with Dr. Bishram Singh, Chouhan. Sir, please, it is over to you. You can share your experience on using the PCT International, and further when you are entering the national phase, entering the multiple countries. Please share your experience.
Yeah, sure. So basically, I mean, when we are representing like individual companies, but generally the sense what you will get out of the complete discussion would be overall pharma industry of India. How does it feel and how does it take PCT and systems? So especially in Sun Pharma, we have been like quite transitioning from pure generics business to now to more of the innovator side, wherein we are like focused on the brands and complex generics. And when we talk about brands and complex generics, they are developed by a lot of innovations. Innovations means inventions. Inventions means that we have to protect our IP. And again, when we are talking about brands, this is like for the global development, and mostly most of the Indian pharma companies, they are shifting their focus from generic business to more complex generics or the branded side. Protecting brands is important, and we try to take our brands globally. I mean, that's like a huge number of companies. And when we talk about patent filings, PCT has all those advantages what a pharma company would like to have strategically. See, I mean, we already have heard in earlier session that PCT gives us advantages of like delaying or deferring the cost incurred for the patent filing globally. You get more time to strategize things, and then you also get time whether to make some documents public or you want to withdraw them from the publication also. So with around 157, 158 countries presence, WIPO, I mean, does gives a clear advantage for us to file patent applications and strategize how well we can go in various other geographies also. And it gives you many types of other advantages also. I mean, depending upon your main business market of interest, you may select your international search authority. By that, you might be like in a better position to judge how your invention is going to prevail through the local patent office in those markets. And I mean, that's it. I mean, so for us, like Sun Pharma, I mean, we have been like quite aggressive in filing patent applications, and probably we are the topmost Indian pharma among the Indian pharma companies. We are the topmost patent filers, and we definitely prefer PCT route. Thanks.
Thank you, sir, for your sharing your experience. Next, moving to Mr. Manish Garg. Sir, how can companies across different industries, agrochemicals, pharmaceuticals, biotech, strategically utilize the PCT system and strengthen their global IP position, secure competitive advantages, and facilitate international market entry? And what are the biggest challenges organization face when transitioning from PCT filing to national phase prosecution?
Thank you, sir.
Yes.
Let me tell you, I joined this group in 2014, along with my colleague who's sitting here. When we joined here, we did not have a single patent with us. Not a single application was filed. We decided to move ahead to start to create a patent platform. Because in the long run, apart from the domestic market, we will have to move into the global market. That was a long-term strategy. But for that, we needed a patent portfolio. We started filing from 2014 onwards. Now, 10 years down the line, it's almost now more than 10 years. Today, this group holds 90 patents granted, of which 5 patents are international. And just imagine, of these 90 patents, 10 patents have already been commercialized in the local markets. So we have gone to enforce, not only make the products available to the farmers. And one of the products is hot selling. Of course, the sales are extremely good. We are also trying to enforce the rights. But equally important was to enter into the global market itself was challenging for a company at that point of time. What would really lie ahead? So we started off with small for 1 or 2 international filings with PCT route, of course, because we were clear that once the PCT route report is available with us, at least the confidence level would be available whether to move ahead and give a sufficient timeline to explore the different markets. In the initial stages, we focused only on the 2 markets. Then we started for US and China. In fact, in both those countries, the patents have been granted. That is going to be a long-term visual how to use that filings now to our competitive advantage in those countries. Now, at that time, India was never was a part of the International Search Authority, so we had to use our conventional countries to use the search. Now, after that, in current position, in the associates in Rajdhani Petrochemicals, since 2020, we have filed a lot of aggressively gone on filing patents, both domestic as well as international. Total PCT, if I have to tell you the figure, almost 20 PCT has been filed till date. Till today, 18 PCT applications have already entered into the national phase, not only in US, China, Brazil. We have also covered Asian countries like Philippines, Thailand, Indonesia, or also some of the non-PCT countries like Bangladesh and Argentina. Also, we have covered Colombia and Mexico, recent addition to our list. So, in the long-term access, today Rajdhani Petrochemicals holds almost 16 patents in the span of just 4 years. Because of the procedure that our this unit is MSME registered, and we use that as an effective tool how to push our applications at a speeder track. So we could manage to get it, and one of the patents we are going to commercialize it next year once the registration approval gets through. So this is an advantage which the PCT route definitely gives you an advantage of exploring even if whether to move ahead or not, and that's why we prefer to go for those PCT countries to PCT route. Of course, cost would be still be there, but it minimizes your it delays the further costing. What you thought for going for 5 or 10 countries, if your report has some kind of a balance, then instead of 10, you might focus only on those 5 countries. That makes a more cost-effective approach. So this is how we have strategized our approach for DAC, and we continue to do so, because that's the only way we can explore and push. And so this is a beginning we have made so far in this domain of IP. Thank you very much.
Thank you, sir. Is there any legal and commercial obstacles to maximize the patent protection and enforcement that you face?
Now, this is a point. See the challenges you're going to face. Now you have a patent. Just taking a patent is not the only option. That's give you a standing position, but you need to commercialize. That's one thing, because what you are going to get a patent is you are going to consider as a part of expense, but you need to convert the expense into revenues. And how do you go to convert into revenues? By monetizing your patents, by commercializing it. In the current way, for one of the patents, we have already enforced our rights. 3 infringers, the orders have already been taken from Delhi High Court. 1 order has already been taken from Hyderabad District Court. And couple of orders are still pending before the court. So we are trying to enforce our rights so that that's a last option for us. We always believe in collaboration with our partners so that we minimize the unnecessary risk associated. But then at times it's necessary to have your rights enforced and let people know, yes, you have a patent, which is not only a valid patent, because that's how once you litigate in your high courts, your validity of the patent is actually judged. Either it is taken in the revocation proceedings or in the post-grant proceeding, in whatever way. But litigation is one option where at least you have fair amount of confidence that people know that this is a company which is really serious in enforcing its rights, and they know that this is a gray area that needs to be addressed systematically. People know that today, if you look, everyone knows online which patents have been granted. Everybody is knowing because of the system is so flexible. Everyone knows which patent is granted. So nothing new for today where you don't have access to any information as far as patent grants are concerned. Everyone is aware of it. So people know, and the competitive environment in which we are working is highly volatile. We all know that, and we have to work in this domain. There is no escape route. We have to move on into this turbulent water, and that's how you are going to survive. Thank you very much.
Thank you, sir. Next, we have a special expert, Mr. Kaushal Joshi. He's from the Kashiv Biosciences. Sir, we would like to hear from your bioscience background that regarding this protection of biodiversity aspect and the traditional knowledge aspect, and what are the challenges that you face while filing the application in either in the international phase or multiple entry in the national phase, and what is your suggestion regarding that?
Like before directly reaching to the point, I want to initiate that I see I have been seeing a lot of transformation in PCT applications, and now what I believe is that PCT is become like a very strategic tool, and given to this biologic science and biosimilar domain, where most of you must be seeing like the cost of the drug is very, very high, and brands are very keen in maintaining their life cycles. So how as a being in India, when I joined this organization 6 years ago, we had no much inclination towards filings, but in last 6 years we have filed around 50 PCT applications, total 150 patents applications around the world. And in biologics, I feel investment is very high, and patenting is one of the way by that you can really, really secure your investment. But the downside is, the flip side of the biologics is that it's a very complicated process compared to small molecules. Challenges are very high, very highly uncertain whether we will get the result or not. So, as we all know, from provisional to PCT, it's a 12 months time period, and within 12 months time period, sometime, or not sometime, but most of time, we are not absolutely ready for filing, or but other hand, we do not want to lose the priority also. So, the advantage of the PCT is that, you can directly go to the PCT after 12 months, and with the time, it's provide you a global protection. It's it doesn't allow you to get the patent, but it's to give you a global protection for next 18 months from the filing of the PCT application. Now, like, means if you, so as per my personal practice, what I have been observing that in last couple of years, like last 5 to 6 years, US law have been transformed, which is the one of the key jurisdiction where like cost is very high and every Indian generic wants to reach to that market. And that is actually one of the objective of our Honorable Prime Minister, that he want India to be on patenting field ahead compared to China and other nations. And I can see like couple of like most of young kids are here, and I believe that if they are from the science graduates or like promising lawyer or about to start their journey in patenting, it's PCT is one of the very effective tool. By that you can file your applications, you can at least conceive your concept, and then it give you ISR and the IPRP, and by that you can check the strength of your invention or work. So the one of the challenging thing in PCT is that by the time like we complete our 12 months, we are not sure like about our sequences and what type of sequence we should give, not give, and it's not a so thing is that we need to keep filing couple of patent application, and I believe applications filing should be more economic and affordable. However, like in last couple of 5 years, I have seen like most of pharmaceuticals or any in-house team has started their own filing. But still with the cross perspective, we need to really work it out on PCT side as well as in biologics. We are seeing that number of big companies from US or Europe, they keep filing certain type of nuisance patents and patent applications, and that creates a very uncertain model to the developing nations. You are not able to decide whether your this all investment will be really in the right direction. So there are a couple of litigations I can tell where especially in US, where they found generic has absolutely lost because of not having a right investment or right strategy on the PCT filings. But there are several good parts I consider in PCT. One is for startups, they can always opt for licensing out, which is the new provision. We have a third-party observation available. So you just see when you file PCT, consider your application deemed to be filed in 160 countries. Now you are not okay with your competitor patent application and you submit your observation. Your observations means you challenge their patentability, then those patentabilities conveyed to 160 examiners, and they are able to see your comments and they can take action accordingly. So I believe that is one of the very promising feature, but given to the biologics sequence listing as well as the colorful drawing should be allowed in PCT, because in biologics we deal with so many of variations and if we can show more in a graphical effective presentation way, that should be really good. And translation cost during national phase, we should really work it out, especially with respect to Japan and China, because as per my practice, I believe the translation is very, very high, and that's why sometimes you cannot go for all the kind of application in Japan and China. And these are my preliminary observations on PCT. So suggestion is that although PCT should either PCT should start providing a translation service, or when we elect let's say ISR and IPRP, that time we should be having some kind of service available which cannot the nominal cost we can go in China and Japan and we can submit. So that is my one of the suggestion is. Second is for sequences, like, means I can see like there are a software upgradation. So now it says ST26 compliance software. But my thought is like, means in personal view, like, what I always feel, people struggle and it's a challenging to really comply with that requirement. And if we can go by like simple in word formats or in other more easy way to fix this sequence listing, by that, like, any normal person can easily utilize this service, that would be really great.
I like to add here, that's a great point. I was talking to my paralegal team, and while filing PCT applications, especially when they have to list some sequences, they do have a good amount of trouble to use this SL26, the tool what we have for. If we can do something about it, make it more easy, make it more friendly, that would be helpful for sure. Yeah.
So I think like these are the key observations on PCT, and we can improve.
Thank you, sir, for the sharing the challenges and your suggestion on that. And I think they have announced already. We have the e-help desk. Further, already Mr. Gomes already explained that demo also. This is very well taken, whatever the suggestion you have given. Next, I am moving to Ms. Manisha Tiwari from Alembic Pharmaceuticals. This recently, ma'am, we have gone through this. There is a meeting with the School of Ultimate Leadership happened, wherein I came to know that the chairman of Zydus, Mr. Pankaj Patel, he had a vision that India can deliver 100 new chemical entity or new drugs by 2047. By 2047. So in this regard, I would like to know from your company perspective, how you are acting towards this R&D and this capacity of the R&D structure, and you can share how we can go about the global level taking our innovation in protection in the multiple countries. Please share it.
Sure, thank you. So since last 10 years, I'm defending litigation, and I strongly believe to defend litigation, one should have really a great prosecution landscape around them. And how we can achieve this great prosecution landscape? By filing more patent applications through regional patent offices and also globally through PCT. And these applications should be the quality applications so that it can create or build a great portfolio around. As we all know that we are moving from generic, as my colleague said, we are moving from generic to complex generics to biosimilars. So this really require a great work and a lot of collaboration strategies to work around R&Ds so that everyone should be aware about the importance of filing and prosecution. How we can achieve this? To achieve this, multiple strategies are involved. One and very important thing is creating awareness. Awareness like the current sessions we are having. So we should have more sessions like this. And we should have more sessions with the real users, with the industry participants who are really working and filing on the inventions. We should let them know the importance of filing and prosecution using the global platform like PCT. And we should recognize the importance of PCT by making our team aware that once you are filing your application in PCT, you are getting a global search report so that R&D will understand the importance of their invention on the basis of global search report. They have time, because if you will go through the conventional route, the time limit is less. And if you will go through the PCT route, you have time limit to improve further on your invention. So by making all these awareness session, we should really strengthen our R&D so that we can have motivate them for more filing. The another way we can do is by providing financial incentives, like providing, as a lot of pharmaceutical companies or SMEs are moving forward and filing their patent applications, and it's a really costly affair. So we should think about some kind of financial incentives wherein we can either think about providing some kind of subsidiary or providing some kind of incentives on the basis of number of filings. Maybe government should also involve and provide the kind of benefits on the basis of number of patent filing or number of IP filings. So some kind of incentive should be there. Apart from this, we should have more recognition or rewarding program wherein media should get involved, and they should, the R&D efforts in terms of filing patent application should be noticed through media, so that this will spread the awareness in the system. So, I mean, in nutshell, the real user should get involved to get in such kind of training sessions. We should have more training sessions. Maybe in WIPO training modules, we should have modules wherein the users can have more training sessions, can enroll themselves, and once their training is over, they can put real-time observations or the challenges which they are facing. So on the basis of those observation and challenges, we can always come up with the ease of system wherein the procedural part or the administrative part of the filing can be taken care of. Thank you.
When you are entering into national phase in multiple countries, did you face any challenges while responding their query or in meeting their requirement?
So not really. I mean, of course, the number of interactions are involved, but I think those interactions are for the benefit or the quality of the inventions or the work is required. But I think the process is quite smooth, and day by day it is getting smooth. And one thing I really want to appreciate about the efforts which WIPO really put in is when previously we used to file the PCT applications, we used to separately request the patent office, regional patent offices to provide the priority application, and which really requires a lot of time. Now, I mean, through DAS system, it is already updated. So this is a great initiative, and we really appreciated it.
Thank you, ma'am, for the suggestions.
Thank you.
Regarding this support, though I am moderator, it's my duty, and in fact, I feel proud to record here. The government of Gujarat is playing proactive role in encouraging the intellectual property right. The education department, through they have published Student Startup and Innovation Policy 2.0 under the National Education Policy. So they are offering financial assistance. Let me briefly read. For patents, domestic filing 75,000, and for other countries 1.5 lakhs, copyright 8,000, trademark 12,500, international registration of marks 50,000, industrial design 9,000, plant variety 33,000, semiconductor integrated circuits 15,000. The innovation hub under the state level IP facilitation center is taking care of this thing. So we had the discussion with the pharmaceutical bioscience background. Now we have Madam Gopi Jatin Trivedi. She is the expert in multiple disciplinary. I would like to cover something related to engineering field. Madam, my questions to you: in what ways does the PCT facilitate cross-border technology transfer and commercialization in cutting-edge fields like AI, Internet of Things, and quantum computing, and renewable energy, etc.? And what are the biggest challenges that industries face in leveraging the PCT system for protecting and commercializing the innovation in these emerging technologies? Please, ma'am, please, over to you.
Thank you, sir. So I'll refer to the presentation of Mr. Roberto, with which we specifically listed out the top filers of the world. And if anybody has noticed, they were all from technology side, right? So, and we are all end user of the technology. This hall is full of those patented articles, right? Starting from this mic in my hand to the camera to the USB. These are all the end products of some innovation somewhere, some patent filing in the region, then PCT filing some in the appropriate offices, and then not only that, to even standard essential patents and the patent pools. So this entire activity of having those products being useful to the end users like us and spread across these entire globe. In fact, the technology has been a new religion, I would say. So this is all has been possible through the international filing platform, fondly known as PCT. We have been the extensive user so far as an attorney. From all diverse disciplines, we have some great, promising and successful case studies also, where it all started from basic inertia of even not filing patent application in the region, India, but breaking that inertia and moving ahead, patent filing in India and then PCT. Now the PCT has a great advantage, as rightly been discussed. Putting them together, you have 18 more months, if not anything. And that 18 more months gives you the freedom to decide which in the markets you want to explore. So you have the financial freedom. This is greatly backed by the search report. And we really swear by the search reports. Thank you, WIPO platform. They give very detailed report with the right documents in place, with the right reasoning. So these report gives you the first-hand confidence in which market to enter. If the report is really not positive, you can avoid all the financial cost involved in your business decision. So that gives a great advantage. In fact, PCT has been now an imperative tool, and that has been greatly helped by the Indian Patent Office also having very reasonable fees for PCT filing. So the joint efforts by WIPO and the Indian Patent Office have really made the life easier for the stakeholders and of course for the attorneys like us, along with the expedited examination. So with having PCT filed, having expedited examination, this has been quite productive output we are able to provide to our clients, and clients eventually can do better business decisions on basis of these IP rights. So if I conclude, I would say PCT have been an inseparable tool for all IP filers, or for the at least patent filing aspirants. And for startups, yes, they think globally, but that's not enough. You have to act also globally. PCT is the only tool. That's something from my side.
Thank you, ma'am. Now, this recently one article has come in the business line, why patent applications have ebbed. It was a beautiful article written by Mr. Sanjeev Sanyal and his team. So they have concluded that low R&D spending by the private sector is now the major stumbling block. The Patent Office has improved its capacity to process applications. So in this regard, I would like to know from Dr. Bishram, sir, that what is your strategy that to increase the protection of your innovation in multiple countries, to increase the number of filings? I'm not asking you any secret of your R&D. Just share that your in general view.
If I talk about Sun Pharma, our number of filings are like increasing year on year for sure. So, and the expenditure, I mean, see, our profits are increasing, so, and there's a fixed part, 10 to 15% of profits, which goes into the research by default. So our management is quite clear. The next in thing is going to be the innovation. If you are going to be a simple generic play, you are not going to survive down the line for sure. Innovation is must, and for innovation, expenses are required. We are expending. From a largest perspective, I agree with this article that, I mean, if at all the innovation is going down in our country, it is definitely because of, I mean, prime reason is like the expenses or the expenditure on the research is getting reduced. So that has to be like dealt, I think, category-wise, looking at the industries, which industries, where and how we can bring them up to increase the innovation. They cannot be in my opinion, there cannot be a general formula which can work across all sorts of industry. There might be some other limitations for pharma. There might be some other limitations for example, auto. So that way, I think it has to be a collective role to play, like including government and including the private sector players. But the basic thing is like, unless we innovate, we are not going to survive in future, for sure.
Okay, thank you, sir. Sir, Manish, sir, you have filed multiple applications with PCT International, and in fact, National Patent Entry also you made protective invention in multiple countries. When we are talking about the benefits of the PCT International system as an end user, that can you give a brief about how commercially you benefited your patent in the multiple countries?
Yeah. Now see, basically when we decide to go to a global market, like if you go to the conventional route, as the Paris system is saying, there are loopholes which we all know, because you are going to start spending the money immediately within 12 months. And then you are going to file multiple applications, multiple requirements, multiple filing dates. So that adds to your woes to what is going to happen at a long run. Expiries would be different, what is going to happen. Here in PCT, what happens, at least once you file an application at the initial stage, I use a search authority. Now, we used India as a search authority as in today for all my applications, which was never there in the past. Why we did this? Because we all know that even if I use any search authority like Austria, whether I use US or Europe, ultimately the patent grants that are going to happen will be from a national face country. They will be bound by their own rules. Of course, the PCT system report, it is quite exhaustive, because my own experience is when you look at that report which comes out, they don't only give you the search report, they give you a written opinion on that. What those D1, D2 documents that have been classified as X and Y, because they have specific meaning on that, what is meant by X, and for which citation they are taking X, for which citation they are taking Y. Once that is there, once the report is there, once you know that we have a fair chance, now you decide, based on this country by which I am able to move ahead in which direction. Now, here is one case why I still prefer PCT, because in some countries, the examination reports are quite liberal. The examination system is quite liberal, let me tell you. Not like United States, not like Europe. They have very strict examination guidelines. But in some countries like South Africa, if anybody had an experience, if you have a good search report through PCT route, they will not undertake any detailed examination again. There, the chances of getting patent in such countries are quite high. And that gives you a very fair confidence to why one should go for PCT. Secondly, you decided in the right from the beginning, okay, I want to target 15 or 20 countries. But we all know the market condition changes quite fast. We are highly in a turbulent point. What you thought before and what you're going to decide later, there is a change in the strategy because the report which comes out, and also because of the market conditions are behaving so abrupt. What you thought to go to that country may not be feasible today because the condition does not allow you to do that. Because of your own financial health also. Your own company is facing financial conditions because the market conditions, you are not able to get good returns from the market. So that adds a little burden to you to whether to go. But still, your focus for filing will still go on. It may be slowed, but does not stop altogether. So still, I would figure for PCK countries, one should go for PCK at least the confidence level that you achieve. And then moving ahead, because the report is quite good, if you still have a problem, there is another provision in the same PCK to go for demand. You can amend the claims and get it again examined so that you get further time to evaluate. And once that final report is available, then you take a final call on that. So that at least that timeline you spent 1 year time that is given to you by PCT gives you enough time to develop the confidence, evaluate your options carefully, which was not there in the previous case. So hence, PCT definitely gives you an advantage, plus the kind of a report that is coming up, go with that report. Still you can argue with the different patent offices at a later stage, even if they have a different report, but that confidence can still take you move ahead in that direction and ensure that you could manage to get the patents in those markets for which you are looking for. Maybe here the search is based on the coverage that you have kept. At a later stage, you may have to limit the coverage of your scope in many countries. Please remember that. You may not have the same coverage as what you had in your PCT application. In the national phase, it so happens that every law has its own law of looking at your patent application. They might ask to limit, not beyond. That is one thing very clear. They might ask you to limit, which you should be able to limit in order to ensure successful run. So I feel that PCT still continues to have a way in the current environment, in whatever future will have a way. Of course, for non-PCT countries, we don't have any option than to file a non-PCT application, go to the government. That's where nobody can help it unless they become a member of PCT. Thank you very much.
Yeah, thank you, sir, for highlighting this. This is the real motivation, this panelist that you are giving to the participant. Of course, the law differs from country to country. We have, India is having some stringent laws. We have, this section 3 we have. And some other countries, it can be the use and the method of treatment. So accordingly, you can proceed. Good.
If I have to really look at India also, the reports are not coming. It's very difficult at times to argue at the time of hearing. We face challenges on that because your scope is so wide. Maybe because, and that is going beyond what is being expected. So we have to limit our scope. So there is no issue on that. We are willing to do because in the good old days, the patents have been granted, that's a different look. But today, we are concerning with the coverage, what matches with what has been written in the complete specification. And that's what the patent office is doing right. And that how today now the system is going to work. Whatever coverage you have filed, you have to limit yourself to the coverage what you are mentioning in the specification. That's why the drafting is a very, very challenge. Even in the litigation, if you are not good in drafting, you are filing a suit of infringement against someone else. If someone counter challenges you, you are in a suit. And that happens. And that has happened in the past. So many examples with the big companies have faced because of the wrong drafting, they lost the case. Pfizer versus Hormann-La Roche, that old case, if you remember, which had happened. Why Pfizer couldn't successfully challenge, take an infringement? Because the poor drafting which could be proven in the court of law, that this is wrong drafting, so they have an easy route to escape. And that's how things happen. So in litigation or everything, proper drafting, proper coverage gives you an added advantage. So you will have to think in the long term, even in the challenge like where you file a PCT, whatever, you'll have to look at the long-term perspective, not only from the market potential, but also in case you're going to litigate or someone counter-challenges you, you should be willing to argue on that. This is very, very working. And as I've said, the last and final point, challenging a patent which has not been worked, at least in India, is the biggest challenge. I'm telling you, you can challenge those patents in United States or Europe is okay. होता है वहाँ पे. But India, if your patent is never worked and you are enforcing our rights, will always put you in a back seat at a later stage. And I have my own personal example which we have done. I can share you that if time permits me.
Yeah. Mr. Kaushal want to add something, I'll give him some opportunity.
So very excellent point, sir. So I just want to tell, like, he was one of my senior, like, when I initiated my career in IP, and I want to just extend his point that it's a really, as I said, like, PCT nowadays I see as a very strategic tool. So it's really depends on the drafter skill. Like, just want to give example in recent case laws, what I have been seeing in US. So their written description and enablement requirement has significantly changed what we used to think 7-8 years ago. So by having a PCT, how this is helpful is like, means when drafters draft, let's say like, multiple dependencies claims. US consider them as a part of written description, but Europe doesn't. So you can always customize your PCT based on your interest. That exactly he wanted to say, like, means, so suppose if I have a country of interest is US and Europe, I can always customize my draft based on my personal experience or having a knowledge about country specific law. So when I enter into the national phase, definitely I would be more entitled to get a better patent protection in US, or I can get a adequate patent protection in Europe. But just filing a PCT without having a proper thought process would definitely compromise the effect or the benefit of PCT.
Yeah, thank you, sir. Mr. Bishram, sir, want to add some suggestion on? Yeah. Do you want?
Yeah, so one suggestion for WIPO per se. It's again about search authority, and as like our panelist has said that in many of the countries, the patents do not undergo examination process. They get granted with the as-filed claims. So importance of the scrutiny by the International Search Authority at the time which we select at the time of WIPO application filing. So if we select Austria or like Europe, US, they are like very stringent search authority. They do thorough searches and they give us very relevant prior. They are like few of the countries wherein the searching is not up to that level as we see from, like, for example, like in China or from India. That has to be something like, harmonized or like uniform way has to be there for, as per the, rules are like equal and same for everyone, but still the kind of search report which we receive from some of the searching authorities is quite sophisticated, whereas from some of the other countries it might not be that good. So that's...
Yeah, thank you for your suggestion.
Yes.
So this actually, novelties, it's the, as on the date, filing date, it should be novel over the world. So it depends how we are saying it's novel. Searching and not finding is the novelty. This is a simple explanation we can give. One example I will give you. So when the landmark case in the Indian history, the Novartis case, Martini-Mesley case, when our examiner found one citation, that Zimmerman patent, it is not there in the STN itself. Few years back, they came to our office for introducing this STN database to us. So they collected the journal from us, later they uploaded it. So the interpretation differs person to person. Of course, we are, this is improving, everything is now, we are moving to the international standard as we are moving from modern office, like you are saying 1 lakh grant, complete digitization, and we are transforming from modern office to model office. So one last question to panelists, what we have to do for increasing the number of PCT international filing? We have discussed a lot the advantages, the simplified format of the system and everything. But what else, in addition to the suggestion given by the other panelists, if you want to add anything, you can give something. What has to be done really on the ground level to increase the international filings?
So this is, I think, very, very this is a big challenge for everyone. And because when you file an international application by anyone, of course he has to look where he wants to enter into the domain. Unless and until this focus moves on, now we have startups, now we have MSMEs coming into picture, and now they are gradually moving into that arena for global, apart from the domestic. So I think over a period of time, you will file more PCT coming up, because what is happening is most of the industries today in India, as I have already said, because the global market is again, now what happened, recent announcements that are coming from United States is creating jerk globally because of the tariff or whatever the issues are there. And that is going to really put a constraint for investment in other countries by those companies. So, if people are not going to invest in those countries, so filing becomes a least concern for them. They take a back seat. Why should I put my application in a country which I don't want to invest? That's always a business decision that comes into picture first. And that is a crucial area. I think over a period of time, once this dust, which has just again erupted because of some announcements on the tariff, gets settled down, maybe you will start moving up, people will start moving into that direction, because it is always a temporary phase. It's not a permanent solution that comes up. You will find that people will start moving more filings over across, because the decision to go to the global level is now having moved forward. And that will create more filings.
So,
yes.
okay. Thank you, sir. So now it's a time to interact with the participants. We are ready, our panelists are ready to answer any question. If you have any specific question to our panelists, it's open to you now. Yeah, man, can you please give mic to the, anybody is there?
Hello sir, I am Ankita Shrivastava, Dr. Ankita Shrivastava from academia. I am representing Pandit Deen Dayal Energy University here. My question is that we have seen the cases of biopiracy in past. So how this PCT will help in dealing with that biopiracy cases, whether it will be covered or not under this? It will not.
So, Mr. Kaushal is the right person.
So like, I want to understand more deeply about your question. So when you say it's a biopiracy, it's like something with the sequences side you are talking about?
No, sir. For example, like we have heard in past that US has patented neem tree in EPO. So in that way, I'm not very sure whether my question is right on this platform or not, but that sort of biopiracy cases would be dealt in this particular, will it be covered under this PCT thing, where 158 countries are coming together or something?
So to answer to that question, Indian government has initiated a few years back, maybe 15 plus years back, a traditional knowledge digital library called TKDL, right? And they have documented all our scriptures into searchable English document, and that activity is still on. So now they have a very rich resource of those important documents which are translated and can be searched, number one. Now with these actions from Indian government, the TKDL has been made compulsory to be used as a search, the database with all patent offices across world through PCT representation. So as an end result, these biopiracy has reduced to almost nil. So hope I've answered to your question.
Yeah. Thank you so much.
Actually, just to add one more sentence to what you're saying, this issue of biopiracy was existing some time back, long back, around 25 years ago. But subsequently, we had our Patent Act enacted. There's a change in the law, with Biodiversity Act 2002 came into picture. The reason why it was done is, anyone seeking protection for patent that uses a biological material which falls which has a traditional knowledge, needs to apply to a particular authority first before seeking protection. That law is now very clear, and the patent office is very stringent in issuing such guidelines. We have to norm those, because I have done in the same way. We have been following those guidelines, and we have been making application to the National Biodiversity Authority, because unless and until they approve, the patent office cannot process our application. That is very, very clear. So in terms of that issue, now no multinational companies are able to use this bioparasitic, because the the traditional digital library is accessible to everyone, and it is a very clear guidelines have been said who want to access, for which the payment has to be made to the government, and they will know which resources are within the Indian governments in the traditional knowledge beacon. So now the issue of bioparasitic is being minimized to a large extent. Almost more than 90% of the cases have come down because of that issue that happened in 96, 97 that we first saw.
Thanks. Any other questions? Okay, no further questions. Let me conclude this panel discussion. Summarizing, we have started this discussion with Dr. Bishram, shared his experience in the PCT international and national based application as an end user. That's the important thing. Mr. I forget your name. Mr. Gomes already explained the benefits of the PCT system and all the advantages, but here we have, as an end user, how he felt while using that one. He shared his experience. Then Dr. Manish Garg sir, thank you very much for giving this your detailed explanation. Proud to say that he is having so many patents in his crown, in both domestic and international level. And the different approaches that you have suggested, that's is very good suggestion. And Mr. Kaushal, regarding from his experience of this biosequence, he has shared the sequences and challenges, and he has suggested regarding the translation also. It's very good. And Manisha Tiwari ma'am has shared about the company perspective. In fact, in addition, she suggested the increase in the number of filing, that awareness, and in fact there's some other benefits to the number of, based on the number of filed by the industries. And thank you Gopi, Jatin, Trivedi ma'am, very well addressed about the other field like Internet of Things and other things, and making this panel discussion effective, and the concept, that real success of this discussion reached the benefit. Now it is time, we are discussing about the benefits, and man without aim is like a bird without wings. So it is, we must have some target. We are talking about increasing in the number of filings, but can we fix a target? I mean, now we are around 3,700 application, PCT international application from India. Can we fix a target by the end of March 26? Can we double the number of filing? Let us work together with a vision to increase the filing to at least at the initial stage to double the number of PCT international applications from the our domestic residents from India. And vibrant Gujarat, a neighboring state, it's a time to vibrate, innovate, file PCT internal application, enter into national phase entry, protect your invention in multiple countries, produce and prosper globally. Thank you very much all the participants. Wish you all the best. Thank you very much for the organizer and the PCT international team those who traveled to reach this our place. This is the first time conducted in the Gujarat. Hope it will be every year. It is our duty to increase the number of filing from our domestic residents filing in the international level. Thank you very much and all the best.
Thank you everyone. Thank you to our panelists for such an insightful discussion. And I would like to extend my warm thanks to Dr. B. Helen Joint Controller of Patents and Designs, IPO Ahmedabad. Sir, thank you so much for moderating this session. Ladies and gentlemen, please give a huge round of applause